Welcome to the Jury Thinks What podcast. Part of the Lawyer Minds ecosystem, the Jury Thinks What podcast discusses everything there is to know about trying cases, from preparing the case before the lawsuit is filed, all the way to trial. And most importantly, how to understand what the jury is thinking. During our journey, we'll be talking to some of the brightest trial lawyers from many walks of life. What makes them successful? What makes them different? Do they have secrets to dealing with the jury? Let's find out. Here's your host of the Jury Thinks What podcast, Saul Gruber.
Thank you, and welcome to the Jury Thinks What, a podcast by trial lawyers for trial lawyers, and I'm your host and guide of this podcast, Saul Gruber from Gruber Trial Consulting. The show is going to be excellent, and I know I say that on every show, but I don't know if anybody's noticed when we have nursing home trial lawyers on, they and I have our kindred spirits and have been through the wars together more often than not. And this time there's no exception. We have Lourie and Suzanne Fink from the Lourie, Chance, Four Lines, Carter and King firm in Atlanta, Georgia. They just had a name change, but Lance and I, and Suzanne for that matter, have been friends for a lot of years. We have spent a lot of time together in thoughtful discussion about trials, why we do the things we're doing in a nursing home case. And I think when you hear their interview, they're going to share with you some of the things they do, which are different, but for them, it's the why they do it. It's why they've thought about it. They're going to talk to you about different witnesses they put at trial next to each other because they want to show the difference. They're going to talk about formers, and they're going to talk about the things you need to have if you're going to ever take a nursing home case. Great stuff. And of course, I'm always jealous of Lance because of his Southern drawl and his way of going about things. But I think you're really going to like this. And it's Lance Lourie and Suzanne Fink. And thank you. We are here. This is the Jury Thinks What. And as I promised, we're here with two personal friends of mine. I feel comfortable in saying that. The great Lance Lourie and Suzanne Fink. Lance and Suzanne have been nursing home lawyers since I know them. I mean, you're talking 25 years, probably, somewhere along those lines. And they are out of Atlanta, Georgia. And Lance just is one of those guys. As anybody who knows him, Suzanne laughs, but you are, Lance. You're one of those nursing home people that everybody knows. Everybody knows you'll know the answer to almost any question. And if you say jump, the rest of us are going, not how high, because we would never do that, but we think to ourselves, should we jump? Lance just said jump. Maybe we should jump. And I think that's really who we're dealing with. Not only is Lance a phenomenal lawyer, but just a really wonderful person. And I can tell you from my own history with him, a phenomenal friend and someone that I could always count on, which there's not many of them. And then there's Suzanne.
There's Suzanne.
So
Lance's sidekick.
You're definitely more than that. And actually, you're definitely more than that. Suzanne, as I remember, I could be wrong, is known as the pressure ulcer queen in their office and has knowledge that we only all hope to attain at some point. So we're lucky enough to have both Lance and Suzanne here. First, thank you. I really appreciate you coming on with me today. It's been hard to get Lance on.
Duly noted.
Yeah. So how's everything going, guys?
Well, thank you very much for those kind words, and thank you for having us. We're doing great. We're really busy. We've got some cases coming up for trial, and we're just glad to be trying them again. Right. Our courts all shut down in the middle of COVID, so we're just glad to be back in the courtroom.
So we have a case that we're consulting on now in Kansas City that was supposed to go to trial next week. And because of COVID, it's not going to be tried until November. I live in Florida now, so I just thought COVID went away.
Yeah.
Right. Governor.
What's COVID?
But are you feeling any of that now in Georgia, that cases are getting adjourned for COVID anymore?
No, we're not seeing that at all. Thank goodness. And even the ones we tried a year ago, I was surprised how little concern our jurors had over COVID. We have pretty expansive voir dire here in Georgia, and I was surprised that we did not have jurors that were reluctant to serve because of COVID. I thought people would be using it as an excuse, raising their hand. Almost none of that, to our relief.
We've been doing probably 4 to 5 focus groups a month now. Really, we're doing 2 in a day, so 4 to 6. I can count on one hand the amount of people that are wearing masks that come.
Yeah.
And they're just not, and they're not deniers by any stretch of the imagination, but they're just not that worried about it anymore. They're feeling they have the shots, and whatever happens, happens.
And depositions are back in person. All my depositions have been in person, which I hated Zoom depositions.
And we're almost getting to the point where, honestly, almost everybody you know's had it.
Yeah.
Yeah, at least once.
Yeah, that's what I'm saying.
Yeah.
I mean, so people aren't as scared of it, as they were, and the particular, COVID that's going around now, for the most part, it doesn't result in as horrible of complications most of the time.
I mean, listen, anything can happen at any point, but isn't that, that's the same with everything.
Absolutely.
But, Suzanne, you said something interesting about depositions and how it's nice to start getting back to taking them in person, especially with nursing homes. Yeah. Right, because that was their excuse for at least a year and a half.
Well, I will be honest with you. I remember I took a series of depositions in a wound case. It was May of 2020.
Oh wow!
And the other attorney said, I want to do them in person too, but for exhibits, I literally threw the exhibits across this very large conference table to the deponent to keep the distance.
Right.
And it's very exhibit heavy, these depositions.
Sure.
It just doesn't work on Zoom. It doesn't work as well on Zoom. It just doesn't. And plus it's hard to communicate and have a conversation and size someone up on Zoom. It just is. So
what we used to do with our experts, I'm going back a long time, was we used to, when we didn't want to fly there, right, or take the train. I mean, being in New Jersey, we had a couple experts that were in Boston that I would take the train up. And then it got silly after a while. We would ship them a binder of the records with exhibit numbers, and then we would just look at the documents together. I would have the same binder that they had, and we would just do it. Then I guess it was over Skype. Mm-hmm. But still, it's not nearly the same because you're not able to be fluid.
I think the judges realize you lose something too. And like I said, I mean, I know Lance has had some Zoom depositions. I have not had any Zoom depositions in the last year.
It really just depends on the case and depends on, if you would have asked me, well, people did ask me, early in COVID, I thought that, okay, when we put up experts, we can do that by Zoom, but I really want to be at the other side's experts for cross-examination.
Right.
And I found the exact opposite to be true. What I found was that I could do a pretty effective cross-examination of the experts by Zoom. If you get 85% or 90%, but that you really lost something in the preparation of your own expert doing that by Zoom. I really like sitting down, spreading out over a table and not feeling rushed. When you're in a Zoom, you just kind of feel like, you got to have like a set list of things. And when you finish, you're just kind of like, okay, we're done. And you just have that sort of free flow of discussion. So I really, if I had to either do my experts or the other side's experts by Zoom, I'll take mine in person and the other side's experts by Zoom. Yeah,
I think Zoom just loses a lot.
But it does.
It really does.
It's all a question of cost benefit. We still like to do most of them in person, but certain cases after you've been in the case a long time, to do the other side's expert, I can, something, if the expert's in California, I'm here and I don't really want to go, and I can knock it out in 2 or 3 hours by Zoom.
I mean, really, in Georgia, do you guys have a report? Do the experts have to have a report?
Not unless we're in federal court. Not unless we're in federal court, obviously.
But really, are they surprising you in a pressure wound case at this stage? What their defense is going to be or what they're going to say?
No, that's what I'm saying. They're not.
That's more expert.
And most of the questions we're asking, but most of the questions we're asking, you can live with either answer. You just need to know what it is. But I think Suzanne's point is well taken. That's a whole different ballgame from deposing, the administrator or the DON or the wound care nurse of a facility.
Because they don't know, they don't have my exhibits ahead of time. I'm not that attorney that sends the exhibits ahead of time.
Well, yeah, I mean,
the element of surprise is my game.
Yeah, well, you know what? Let's talk about that. So you guys both, I know your firm handles catastrophic cases and some whistleblower cases, if memory serves. But the main thing you're doing now is medical oriented, right? Either nursing home or med mal.
Yeah, we still have a reasonable number of general liability cases in the office, but I'd probably say, the vast majority of our cases are either med mal or nursing home.
So let's talk about that for a minute. Then I want to eventually get to a couple trials that you both participated in. One we all knew about, and then another one was a pressure wound case I remember, but I didn't remember a lot of the facts. But so now you've got the nursing home case. And the person calls and says, oh, my mom died and she had this horrible wound. It was the worst thing I ever saw. And you get the pictures and it is. Suzanne, you're probably doing a little bit more of the initial review than Lance.
Yes,
definitely.
That's fair.
I thought so.
Yeah, that's very fair.
So tell me what you're looking for. That call comes in, the pictures are texted to you or emailed to you. What's your next thought process before taking the case?
How is the family? What we've started doing since the pandemic, instead of me driving to meet potential clients, we Zoom with them, which is fine for initial intake. But
sure.
My first question is, how often did you visit your loved one? Or how often did someone in the family visit the loved one? And the other thing, once I walk through, there's no binding arbitration agreement, the wound developed at the facility or it got worse at the facility, and we get the records, I'm always going to go to, if there's a subsequent hospitalization, that's the first thing I go to. How did this resident present from the nursing home to the hospital?
Why do you do that?
Well, because today, for example, I'm looking at a case. The woman has a lot of comorbidities. The photo is bad, but it's not terrible. On a scale of 1 to 10, it's maybe a 6.
Isn't that horrible that what we're looking at, we have that opinion?
But you have to. I mean, this is what I do day in and day out, and I have to do that to prioritize. But so you go to the hospital record, and the first thing I see is patient admits with purulent foul drainage from stage 3 sacral pressure injury covered in feces. Well, so there's the scale tipping a little bit back in favor of, okay, is it worth a medical review? Because it's the whole picture. It's the global. It's not just the photos. It's not just the family. It's not just the venue. It's everything else that a jury's going to hear, and
I'm curious from both of you. I hear from a lot of people all over the country say, oh, this is a real tough venue. You never win cases in this county. Or if they give a verdict, it's $100. Now, I'm sure you have those counties in Georgia. Do you Do you find that you can still do well depending on the case in those counties?
Sure. Well, first of all, the venue is not as important in nursing home cases as it is in med mal cases, okay, as a general rule. And like Suzanne says, there are a multitude of factors that we consider, and venue is one of them, and who the defendant is certainly one of them in a nursing home case. And you can't lump all cases together.
Right. For
example, suing a mom and pop nursing home in a small town where, the owners of it, the facility was started by their great grandparents. And I mean, it's the beautiful window dressing, and there's, leaders of the community and everybody, that's not really appealing to me too much versus a small town where I'm suing, a national corporation. So, you just got to think about all those things. But we all know, Georgia has some very conservative areas, but we know that, conservative people expect accountability, and, these cases are about accountability and about greed. And so we find that we can succeed on them in small counties, but we'd rather be in a more metropolitan county when we can. And, we are more at home there. We know the courts, we know the judges in terms of just, we're comfortable with who they are. We know their style. we're in our home court versus, you go into a small town and you feel a little bit like, there could be some home cooking, and
Sure.
we very often will associate local counsel in a small town because there's things going on that you just don't know about if you're not from there.
Well, the jury panel, I mean, I'm always
Right.
concerned about the jury panel being employed by the facility or having a daughter employed by the facility or going to church with the owners, it's.
What? There are certain cases that I'm actually working on in Georgia, in I guess lower Georgia as it gets closer to Florida, where it's like the only nursing home in the area, and everybody works there. It's
Yeah.
one of
Right.
those situations. It becomes really, how are you going to paint this? Now, it's also, as you can probably imagine, both of those cases are nursing homes that are owned by a larger corporation that's mainly in the Georgia area. It's not too hard to figure out who that is.
Yeah.
But so you're feeling a little bit better. But even then, we focus group both those cases to see what people thought of that company, just that name, and it came back both. We keep thinking, oh, they're going to hate them. They're going to hate them. They don't always hate them. A lot of times
I agree.
they really like them.
Yeah, I agree. You got to be really careful with that. And the assumptions we make are often not correct. You know?
Yeah. David Hoey, who we both know, all three of us know very, very well, said to me years ago, he needs three things to take a nursing home case. He needs a really good family, which I think you've talked about already, a really bad facility, which I think you've kind of referenced, and then either a horrific act or just a horrible, horrible injury.
That's fair.
And I can tell you every time I violated that rule, right, because we're going to, but look at the pictures, look at this. It bit me in the you-know-what.
Right.
Every time. So I love the way you guys are thinking about, we're going to pass on that case. There are other lawyers who can.
Yeah, we pass on a lot of cases. I sort of view it as a couple of things. I sort of view it as in those initial assessments of the case, you're not looking whether to take the case, you're looking for a reason to not take the case.
Right.
And you're kind of checking boxes. Families involved. Am I stuck in arbitration? Where's the case going to be? Comorbidities. Does the defendant have money or insurance?
Which, Saul, I forgot to say, the first thing I do when I get a case, even before I have a Zoom call with a potential client, is I go to Medicare.gov, pull up the facility, see the star rating, and then go to the owners. Because there's certain facilities we're just, mostly for financial reasons, we're not going to touch.
It's crazy. I'm listening to what you just said, and I want to say to you, well, of course, obviously. And then
a lot of people don't.
And then it dawned on me that most people are going to be listening to this don't even know what you're talking about.
Right.
But, I used to do when I was still in the circuit teaching other lawyers how to do nursing home cases state by state, I would say all right, there's a stage 4 pressure ulcer that becomes infected and leads to the person's death. Who here can give me the value of the case? And you'd have everybody raising their hands and they're all coming up with numbers. It's just, you did it on purpose. I'm like, man, how do you even know? I haven't even told you who the defendant is yet.
Yeah.
Right.
Because to me, that's so important.
Yeah. Yeah.
Right.
Yeah.
I agree.
We're seeing a lot, but just lately, I'm seeing a lot of strange things. It's not these big corporations anymore. It's these groups of individuals and these holding companies and some REITs. So I'm feeling all that out. It's not just the big corporate demons that we used to see all the time.
Man, I mean, I know I'm Suzanne's answering because we haven't gotten to the trial stuff yet, but I'm seeing a couple companies out of the New York, New Jersey area.
Yes.
That have bought, I don't even know where they got the money, bought maybe 200 facilities during COVID.
Yep.
Yeah, it's really weird.
Their individual names are all the same and all the, So I'm kind of, we haven't gotten far enough to, and of course you send a letter out to make sure there's coverage before you start pursuing the case. But that's interesting. Yeah. I don't know it's a lot of change of ownership lately.
Yeah.
And my question is, if you're buying 200 nursing homes, each nursing home has to cost between 10 and 20 million, I would think.
You would think.
I don't know where that money comes from. That's an awful lot of scratch.
That is.
But we digress. So getting back to, you've got the case. Now you take a look at it, and I know we spoke a little bit off before we started, and I think I know what your answer is going to be, Lance. But Suzanne's taking a look at it. She said, you know what? I think this is something. What do you guys do next?
I always view it as you're sort of tiptoeing and wading into the water. Every step you're listening, taking in information, and you're prepared to turn around and walk back.
Right.
Does the story interest me? Okay, I've heard the story. Now I've met the family. Am I willing to go a little further? Am I willing to look at records? And but I think to answer your question, your question is, we've already gotten the records and we think it's a case. We think it's a case. Then we're going to send it to an expert. And Suzanne's going to, we have to have an affidavit attached in Georgia. So Suzanne's going to start working on the affidavit, assuming that the expert thinks it's a case.
Sure.
And then, we're going to get it filed pretty quickly if we can.
Yeah.
Now, I know you guys, like most really smart nursing home lawyers, want to find, they call them formers, where they, people who no longer work there, but really know the real scuttlebutt about the place. Do you try to do that before you file suit or after you file suit?
Usually after. And we don't do that in every case. You sort of got to figure out the cases that, that warrant, because it's expensive. It's an expensive undertaking to really hunt down these employees. And
well, let me interject there. You can't really do it before because you don't have access to that information. It's information that we request in discovery that they 90% of the time don't give us, and we have to move to compel it.
Right.
And we've been successful every time, because they'll say, why does the housekeeper or a CNA on another floor have to do with your resident, your client?
Right.
And Lance says, because they're all there. They know what's going on in the facility. They know if there's staffing issues. They know who's coming in, and we win. But it's a lot of work to get it, but it's worth it. I mean, that's, Lance will talk about the trial, but it's worth it.
Sure.
So Suzanne, are you telling me that you make valid requests of the nursing home defense and they don't just simply comply and send you all the documents you've requested?
Very rarely.
Saul, it's shocking.
It's unbelievable to me. I had no idea that was the case.
Some things, if being a former defense attorney and having worked for Lance as a former defense attorney, some things they're just never going to give us, like other resident records. They're just not.
Right.
I've never once had that happen. But some things that we're fighting over sometimes is just ridiculous. Like a list, the names of employees. I mean, how hard is it to print out a roster?
Right. Yeah.
Listen. Oh, it's terrible.
Oh, it's so much work.
Thing.
I think they bank on the plaintiff lawyer just not getting to it.
Right.
Just not getting
absolutely.
And they're right a good chunk of the time.
Absolutely. And they can throw a little money at it.
Mm-hmm.
It probably takes me a good 5 hours to go through discovery responses and check off if they've, especially staffing sheets, are they the right dates? Census, did you give me the months I asked for? I mean, it's time consuming.
Let me ask you this way. This is a question that comes up in a lot of our cases, and we're everywhere. I think we've got cases in almost every state at this point where we're consulting the lawyers on. A lot of lawyers fight back and say they don't want to do tiered discovery. They do it all up front. They send a 15-page request for production documents up front and then fight about it as the time comes. Where are you on that?
Usually we send very exhaustive discovery up front, including financials, which they'll be pushed back because you haven't proven punitives, yada, yada. To which we say, well, that's, you have to staff the facility and provide for the rest. But I think we send it mostly up front unless something weird down the road happens, especially corporate information.
Will you take depositions without getting all that information?
No, I won't.
Now, may not have all.
Well, I'm not going to take a deposition of a wound nurse without the policies, the personnel file. I guess that's probably, but I'm going to fight for a lot of stuff you can't take a thorough deposition if you don't have the policies.
See, I've always thought we know what the policies are going to be. So what we've done is, because I don't want to wait a year to take a deposition.
Well, you're not going to wait a year in this firm.
All right, so you guys are just on it, right? You're just on it.
She's on it.
Yeah, and if you're listening and not watching, Suzanne's just got her fist in a ball and just punching.
Yeah.
And I can imagine I don't want to be on the receiving end of that punch.
You don't.
No, I think I may have
done it to me.
Yeah.
I've got a judge that hasn't ruled in 5 months, and I said to Lance, Can I go down there and ask him what the problem is, Lance?
She was banging on his front door.
Yeah. So now you've got the formers, you get the discovery you want. How important is, Lance, as you're going through litigation, how important is the story to you of what happened?
It's very important.
Tell me about that.
It's very important. And lots of times we don't know the story. We're putting the story together.
Right.
And when we get to the pressure sore trial we had, that's a good case that has a story like that.
Well, I've got one better. Let's get to the pressure ulcer trial you want to talk about and how you put the story together. So
what's interesting
the
about
background
that case
of the case a little bit.
Yeah. So what's some interesting things about that case that are worth just sort of throwing out some red flags. When the case came in, the whole admission was only like 28 days or 20 something days. And it came in, there was an arbitration agreement, but we had the right to revoke it within a certain number of days. And literally we were like a few days from the last day,
wow.
but we were able to get a letter out and get it revoked. Just, that's just some luck there. It was a lady that had a stroke. It had been in the hospital, was put in the facility. In a nutshell, she was pretty high risk for the development of pressure wounds. She was there just for rehab, and wonderful family. And she develops what's probably a stage 2. It's noted by a nurse, but she doesn't contact the wound care nurse, which was their protocol. And then a week later, another nurse sees it, and now it's worse. She doesn't tell anybody. And then a few days later, they finally get the wound care nurse involved, and then it gets infected. And then she's sent to the hospital, and it's a big mess, and she's got sepsis, and they do operate on her.
Oh, wow.
And take out, a huge amount of material of her sacral area. And she's also got a heel wound that wasn't even noted in the facility, that the facility claims probably arose during the ambulance ride, to the hospital.
Yeah, I love those.
And she dies. Sepsis wasn't on the death certificate, but she was septic.
Right.
And went through a horrible time before she died.
And it's bad enough that they actually, what I think they call it a sacrectomy or something like that, where they had to remove part of the infected bone.
They didn't have to remove bone, but they had to remove, a lot of muscle all the way down to the bone. So we had a really good story about what happened in the facility, but what made the case interesting was, among other things, was we started tracking down employees, and we found some employees who had been there during the previous year, but were no longer there. Okay. Now that gave rise to, big motions in limine by the defense. Oh, this case is about what happened to the client in this narrow period of time, and he shouldn't be able to get into evidence what happened, 6 months earlier, a year earlier, 4 months earlier. And that, that's an argument we had to deal with. And then we found the staffing coordinator who had been there, and she was a real good witness, but she had quit 6 months before because she was sick of what was going on. They made the same argument. So we put together a story of building up to the time our client went into the facility.
Right.
We put together a story that the facility and their corporate office were on notice of these problems. And we argued to the court, look, Judge, we're not trying to get in stuff that happened 10 years ago. We're trying to get in what happened in an 11 and 12 month period before our client came into the facility. And we could sort of show on a timeline various things that had happened. The staffing coordinator talked about how she had contacted corporate and needed more staff, and she was finding people laying in feces and people, their water pitchers weren't filled up, and people laying in urine, and pressure wounds not being taken care of. And then we found a couple other ex-employees, and then the judge made them produce it was like 20,000 emails. And not only did we search those, but we literally went through every single one of them, because sometimes the search terms don't show the words. And
well, let me ask you that question, because that comes up in every case. The email.
Right.
I think they're critical. I think
Oh,
it's
yeah.
people who aren't getting emails don't realize what's in those emails.
Oh yeah, there was
Um,
really good stuff. Stuff like, we, management of your labor costs is not optional. Find a way to cut labor. Because we all know that labor is their biggest expense.
Sure.
And then what was interesting, there were complaints. Well, first of all, we found some ex-employees who were on emails, but there were complaints from family members where they had deleted most of the email address, but sometimes we could find it. And, we found part of it, and we had our investigator. They found some of these people,
Oh, God.
I just went through one of our nursing home cases, emails. We had someone outside the office summarize them for me. We have a staffing issue. What are we doing with Mr. Nix's wounds? Are these being addressed? I'm like, oh my God, this is gold for the DON.
We're doing that right now. I'm looking at, we have to stop bringing these agency nurses in. They don't do anything.
Yeah, but why are they emailing each other still? Haven't we figured this out?
Well, that brings up a great question. Is when you ask for emails, are you asking for everything, or are you giving them terms to search?
Terms.
Okay.
Yeah.
So are you how many words do you give? I mean,
5, 6. We're
okay.
We start broader, and to show the judge how cooperative we are, we narrow it down.
More than 5 or 6, though.
No, we start broader, but it usually narrows down to whatever type of injury it is.
Right.
Pressure,
census, staff.
It's always staff and census.
The resident's
That's gotta
name.
be,
Yeah.
Right.
Got it.
And you get some emails about the staff Christmas party, staff parking, and not, but that's okay, because in between those are the really good ones.
I mean, listen, we've gotten emails where it's just been nothing.
Yeah.
That's really helpful.
Yeah.
Right.
Yeah.
But
because it's hard to believe. Right.
Yeah. Well, we haven't received anything that's been helpful. I don't know whether there was anything there that would have been helpful.
Right.
Yeah. The other thing that's kind of interesting is the pressure they put on them to fill the facility, the heads and the beds. A lot of pressure. Competition. The Eastern Division had 14 new admits last week. Come on, Southern Division. You
Exactly.
can top that,
And if you can put that next to the emails between the same people saying, we just don't have enough staff right now. What are we going to do? We can't keep people working here. What are we going to do? We can't care for the people. And then 10 minutes later, they're hawking them to get more census.
And then on that same board, you put up the incentive and bonus program that the DON and the administrator get for bringing in more residents.
Yeah, I mean,
there's that too.
Again, they're things that I like to say that's I want to say it's advanced nursing homework, but it really isn't. It should be what everybody does if you're going to handle a nursing home case, because it's really, we all know it, we'll see it. I mean,
just a lot of work.
And
you can't. I mean, it's important to note you can't go all out on every case. You have to kind of figure out, is this a case that we think we're going to resolve early for a reasonable amount? Is this what I call a special case? This is a case that it's going to take some serious money to resolve it, and we're going to put the money into it, and it's got all the stars are lining up right. We got a great family, we got a great venue, we got good facts, we got maybe some altered records or some good pictures. Not every case has everything, but okay, this is different. This is not a case that they can call us up and offer us, a few $100,000 or whatever, and it's going away.
But when you say 90% of our cases, we have to file motions to compel.
Yeah, I'd probably say maybe not quite 90, because some of them get settled before that.
But it's
really close to 90. I mean,
it's just
the only time that doesn't happen is if they call up and say, just stop, let us evaluate the case. We want to settle it. And some of that depends on my previous experience with that lawyer and that chain. I mean, there's certain adjusters at CNA that, they may say stop. I'm not stopping, because they're going to lowball me, and they've done it every time, and I won't even mediate with them. I'm like, you want to make an offer, but we're not stopping. We're not slowing down. Versus other people have some credibility with us, and we'll say, okay, how long do you need? And okay, they know they know what the sort of the ride we're gonna
Exactly.
give them,
So you were saying earlier, and you're now creating the story now that you're getting into the case, whether it be through formers or other witnesses that you're starting to talk to. And then you were talking about the wound case. So let's get back to the wound case because I'm fascinated by that.
Mm-hmm. So you mean the wound cases in general?
No, the wound case.
The one you tried.
Oh, the one we
you
tried.
tried.
Okay.
Yeah.
Yeah. So this particular client, okay, in this case, we were able to build a story for a year before
Right.
her admission. Huge turnover in the facility, 200 or 300% turnover, lots of people coming and going. The staffing coordinators quitting, families are complaining, and we can show on this timeline this increase in complaints, emails from family members, and even the ones that we didn't know the name of the family member, we still tendered those into evidence. Look, whether it's true or not, you got an email on this day from somebody complaining that her mother's wound care was not being done. They promised they were going to do it 3 times a week, and it's been a week and it hadn't been done at all, and so we argued that was notice of the problem. And we actually, in the motions in limine where they were trying to keep that out, I actually argued that it's really, it's just like a defect on the floor in a grocery store. If somebody says, I saw that banana peel on there last week on the floor, they can say, well, that's a different banana peel, but that's for the jury to determine.
Sure.
I mean, we got evidence that this problem existed for a year. And
let me just say, for a year,
that's
a long time.
And it culminates with what was really the way the story just came together. It culminates with our client coming into the facility, and then about a week later, a new wound care nurse starts, and she was a star witness for us too. And her testimony was, on the stand, we said, well, what were your first impressions when you came into the facility as the wound care nurse? And she said, I knew I should have turned around right then, and she, and she said, there were these huge problems which fit with that story that we had been building. There weren't enough staff. There weren't enough staff to meet the needs of the residents. The wound care wasn't being done. There were no good records of it, and then that sort of culminates in what happens to our client over the next couple of weeks. And then, of course, over that time period, her wound gets bad. She had something else. So it all just fit together really nicely.
Which doesn't happen often, right? A lot of times you have one of them and you're trying to fit it into a square peg into a round hole, and it's just, they're not going.
There are times when it just doesn't fit together.
And so, Saul, I wasn't involved in this trial because I was on one of my many vacations, as Lance will say, but I had worked on the case initially, and my observations as a third party, I think these defendants, I think sometimes a nursing home is going to do better just say, hey, we had a problem. We were trying to fix it. But to me, as a third party observer, and I think a juror, I think they were we didn't do anything wrong. This isn't true. It wasn't a wound. Didn't they at one point say it wasn't even a pressure wound?
Oh, God, it wasn't a pressure wound. If it was a pressure wound, it wasn't caused by us, and it wasn't infected. If it was infected,
I think you're right. I think, my personal opinion, and I'm curious what you guys think, because you guys have had the 8-figure verdicts. I think when you see a high 7-figure verdict or an 8-figure verdict, normally there was a defense attorney who was just an ass, or whoever made the decision, the tack that they were taking, the defense was so stupid that it just absolutely pisses the jury off.
Right. Well,
I think that's just a big mistake.
So I'm not really seeing defendants come in. We've only had one case where they were going to acknowledge responsibility for a pressure wound. I'm not really seeing that, but it kind of brings up another issue that I know Saul and I have talked a lot about before, and that is the issue of the comorbidities. And they were significant in that case, and they're significant in every case, and I sort of love to make the argument.
Not really, though, not rehab cases.
Yeah, but well, maybe not rehab cases,
Yeah.
but most of our cases, the person has
Long-term care there for a reason.
Yeah, I mean, they have a lot of them have diabetes, and
Dementia.
some of them have kidney problems and dementia and heart problems. And
Yeah.
I love to make the argument, and then they go through painstakingly at trial. Every case I've ever tried, they go through painstakingly, charting out, congestive heart failure and diabetes and dementia and vascular disease and this and that, and high blood pressure, and you had cancer 25 years ago, and blah blah blah. And I love to take the position that this is a company that makes millions of dollars taking care of sickly, elderly people. And then when they're negligent and hurt them, their defense is, well, you're sickly and elderly.
Yeah, I mean, you and I have talked about that for a long time.
Shove that back in their face.
I put it right in the opening.
Right.
You're gonna see, the defense come up with big charts, or where they're going to show you each and every condition. Maybe they'll pull out a hospital chart and then they blow it up. With all the ways they do it, think to yourself, who else is going to a nursing home?
Right. That's the business they're in. They're making the money,
But we do it right in the opening, and like clockwork, the defense attorney does exactly what we say they do, right?
Right.
There's the fancy chart where they're blowing it up and they're saying this person was sick, and hopefully we cut the legs out from them. And if you have the story, I think you do cut the legs out from them.
Oh yeah. Yeah. And you kind of watch what the way they word it. We had one case we tried where they said the lawyer got up there and he was arguing that in opening. He said something like, she was on her way out. She already had one foot out the door. Or something.
Yeah.
And the second he said it, you could tell he regretted it.
Yeah.
Every witness, we just reminded him of that very callous statement. Did she seem like to you that she already had one foot out the door? No, not to me. I mean, every time, every opportunity we could. The second he said it, and we've all done that.
I was about to say, who hasn't done that?
And the second I've said it, I'm like, I shouldn't have said that, But you get carried away, and he was a pretty good guy. But man, I mean, it was all downhill from there on that,
And when the defense says, and I don't think there's any secret to anybody who listens to this, that I was a plaintiff attorney for 33 years. I mean, I never defended, unlike you two who started defense, I never did defense. We
don't miss it.
Yeah, no kidding. I'm sure you do. Well, knowing how good you both are as plaintiff lawyers, I would think it would hurt both of your hearts to go back and do defense work.
Oh yeah, I couldn't do it either.
Couldn't do it.
Not only that, I couldn't do it from a standpoint of
who you're representing the right person.
Of course,
the right person.
Billing process and dealing with carriers and
and they think they know more than you, and the whole
they're half our age, Saul.
the whole lack of accountability and the positions they take are just this work is too hard to do if you don't enjoy it.
Yeah.
And I wouldn't enjoy it. No. I would just dread going to work every day. I would just dread going out to the facility, to hear that the 20 CNAs that took care of the plaintiff, none of them work there anymore. And 12 of them left on bad terms.
Yeah.
And we don't know what they're going to say. And I mean, none of that sounds enjoyable to me.
No.
Versus we get to at least enjoy it and get paid to do it, assuming they prevail.
So you've got the pressure ulcer case, you've got the formers, you've got the story. How are you putting together your trial plan? Like how do you decide who to call when and what you want them to talk about?
Well, it's interesting. We do usually do a trial brief because we want the court to understand why this stuff is relevant, and we want how it all fits together. But we always, in those cases, start off with the formers in the trial.
Okay.
The jury's paying the most attention then. And, it's very important, the order of the presentation, as we all know.
Yes.
And you would never want to start out with,
an expert.
And you don't want to start out with, Mrs. Jones was a wonderful woman. She worked in the school cafeteria for 32 years and help the children and walk a lot of them home from school and blah, blah, blah. All that sounds great. But then the jury's just, their mind is just automatically thinking, well, why'd y'all put her there? You know?
Yeah,
and
sure.
But if you can get the jury stirred up and angry and wanting accountability early in the case. And I'm the same way with the opening,
Mm-hmm.
you got to get them, in your opening, you got about 8 minutes where they're really paying attention. Then they're thinking about, am I going to have to pay the extra $6 an hour to pick up my kid late from daycare? And, all the problems that we all have in our day-to-day lives. So with opening, you got to get right to it. And with the case, and we don't call all the formers first,
right?
But
your best former, I
like it's first. Very compelling evidence. The jury, the lawyers kind of cancel each other out. The experts kind of, but these are hardworking people, and we generally paint the picture that they are the victims as well.
Right.
These CNAs. It's a very difficult job, changing diapers. A lot of the patients that have dementia, don't have outward appreciation. They're difficult. They are nasty sometimes to people, and they're difficult to manage. And it takes a really special kind of person who's willing to care for them. And what happens, and I'm sure you've seen it a million times, the good employees, they're trying so hard to do the right thing, and then the cruddy employees are, they're not showing up. And then finally the good ones just get fed up and just say, I've had enough. And that spirals the problem. It's a downward spiral of the problem. It just gets worse and worse and worse. So I
think you're right. They are also a victim without question.
Yeah. So if we can get a couple of good formers up early, preferably our first witnesses. And so we like our formers to go first. And then sometimes we're going to an expert, but sometimes we're going to some corporate people right after that too. Because if we have good corporate, when I say good corporate people, I mean, I've taken a video of a corporate vice president who seems kind of callous and doesn't really have an explanation for the email that he sent that said, we got to cut labor costs, or says that, he or she says things that just aren't credible and aren't believable, and doesn't really seem to have an appreciation for, or an explanation for these problems in the facility. If we can sort of, juxtapose, put those things beside each other, this sort of callousness.
That's interesting.
Understaffing, and then we put up our experts. Profit. Then we put up our experts who can say, and I like to actually, one thing that I'm sure you've struggled with is, how do you prove the understaffing affected your client?
That's 2/3 of the battle, I think.
Right. And some judges will show, they want to hear that, and the jury wants to hear it. And so what I like to do is prove that evidence through those formers.
Okay. And
remember, you can't really put your client up to do too much of that, because that's a dangerous thing too. Because, if the daughter of the decedent gets up and just goes on and on and on about, how things weren't good there, and people were laying in feces, and mom was never, always, then the jury's thinking, well, you should have gotten them out of there at all costs. So what I like to do is, when I get the expert up, now I've got this other evidence in from formers, and then I'll repeat that evidence in a hypothetical. I'll say, I want you to assume that, one of the CNAs was here earlier to testify, Felicia Jones, and she said blah, blah, blah. And she said she couldn't get her job done. And she said that they weren't meeting the needs of the residents. They didn't have enough staff. And she told this jury about how she constantly found people laying in urine, and, and that many days she had to take care of 20 residents. And I kind of lay all that out in a hypothetical, reminding the jury about it. And then I ask the experts about those facts, and how those facts affected the care our client had, and how those facts create, I believe that facilities have a culture.
Yes.
Some of them have a good culture, just like law firms have a culture. All businesses have a culture. And I ask our experts, what do you make of that? And then they just start giving us, they just launch into it. Oh, this is horrible. This is clearly the neglect, and the facility is caring too much about profits. And they're, especially if you can kind of link that testimony with the emails. Now you can say, well, I want you to send that. Then they send an email,
That's what makes the email so damaging. It
right. And then
it lends credibility to your whole argument.
Right. And then you get your expert, your nursing experts to kind of wrap that all together. Oh, this is a big problem. These patients aren't getting enough care. And, it's obviously what happened to Mrs. Jones, or you're just seeing it because of this. And then you do the same thing with your doctor expert and get him or her to testify that testimony contributed to the injury your client suffered.
So,
and that requires a lot of thought. Those questions,
yes.
I'm one of these people that I'm not really, every night during a trial is a late night, but by the time I get to court, I've got all my directs and crosses already. But that's the kind of question that you're tweaking at 12:30 at night, the night before,
Where do you put other witnesses, the administrator, the DON, if necessary, the wound care nurse, that maybe aren't going to be your best friend, and you're going to, treat them adverse? Where do you put them in your plan?
That's a good question. It just depends.
Okay.
Sometimes nowhere.
You just cross them really well when they're put up.
Yeah, but we don't really, we do everything we can to avoid misadventures in the courtroom. That's what I call it.
Yeah.
And so we're not putting up any of those people unless we have a pretty doggone good idea what they're going to say. If we've got a good deposition,
okay,
and we get to call them for cross. When we call these formers, we're not calling them for cross.
Right.
They get, but if the administrator's still there, or the DON's still there, or the wound care nurse is still there, and we took a good deposition, you admit that, you were obligated under the federal regulations, to provide this care, and you acknowledge that the resident's not supposed to develop a pressure wound unless it's clinically unavoidable, and you admit that clinically unavoidable means X, Y, and Z, and you admit that y'all didn't document this, and you admit that the doctor ordered antibiotics 3 times a day for 2 weeks, and they missed 6 days in there, But if I don't have that evidence, really, because you really don't have to call those people if you've got all the evidence, but sometimes you do, but you got to think about, what am I trying to prove with that witness?
What I love about what you just said is I think that means you also have to think about, what are you trying to prove when you depose that witness?
Right.
Oh, yeah.
Yeah.
Because I can't think of a case where those questions weren't asked of the administrator and the DON.
Right.
It may take 4 hours to get those 10 questions that you need for trial, but I'll take the 4 hours if we need to.
What happens a lot of times with
It's a short
those is Suzanne doesn't know what a short deposition is.
I don't.
Oh no, you're one of those, Suzanne. Well, how does it? You have to summarize the depth then, don't you, for whoever's trying the case? Because no one's going to read them.
Yeah, we all read them. We all read. We do. We do. I mean, by the time I get to court, I've read every word of every testimony.
Right.
You're not going to get what you need in 3 hours from a wound nurse.
Right. But what we might do there is, let's say she doesn't work there anymore, and she's the wound nurse. Well, then I'm going to video her. Suzanne's going to take the deposition, and then I'm going to go through, I'm going to pick out of that 3 hours, I'm going to pick out, maybe 25 minutes of testimony. And a lot of times that administrator testimony in our cases is not about the clinical care. It's about proving control by another corporation. It's about proving how the budget was done. And it's pretty boring stuff to the jury.
Yeah, it's like the setup questions.
You get a lot from administrators. My experience, and Andrew took one recently. All they do is say, "Well, I rely on my staff. I rely on my wound nurse. I rely on my DON. I rely on my ADON."
Yeah,
I think
I just set them up. I just want to, how's a nursing home work and why, and that's all I want from them. And
right, but like if there's a a management company or the parent company we're trying to get keeping the case, it can be pretty compelling when they say things like, well, I don't really know where the money goes. And I have to get approval for every dollar I spend, and I have to get approval to fire somebody. And, who do you get approval from? Well, I get approval from this employee, this vice president.
Right.
Where's that person? Oh, that person's in Omaha. How many times have they come to you? Well, I've never met them.
I've always laughed when I get the cost. I get the cost reports in every case, really just to look at related entities and to see what they're paid. That's kind of what I get them for. I know there's a whole nother niche practice out there to use them for other things, but to me, that's what they're all about. And
I agree. That's a lot of it right there.
Well, you and I are old enough.
No, you are.
Yeah, you're older than me. You're older than me. But Lance and I and Suzanne have been through the wars for long enough that we had to actually learn how to read. There wasn't a service out there. We had to learn how to read a cost report.
Yeah.
Kind of figure it out. And then realize that 2/3 of it really doesn't make a difference.
Yeah, so true.
No, it doesn't. Most of the time, it doesn't.
But when they say they paid $700,000 to a management company that's a related entity, and they don't know what they did and when they were ever in the facility, you're like, huh?
Yeah.
Isn't that interesting?
Exactly.
Yeah,
Juries like that.
They
And
really
it's
do.
again, it's trying to escape accountability. It's one company trying to say, "Oh, it's not us. It's not us." Well, what were they paying you $700,000 for if it's
Exactly.
not you? And well, who is it then? There's just that sort of corporate gamesmanship, I think, also irritates the jury a little bit, especially when it's obvious that company should be responsible.
Why not? Like, there's a nursing home. I can say whatever I want. Genesis, right? Which I've always found, not talking about the type of care they give, but when you had a Genesis case, from the therapy has a Genesis name. They're not
right.
They're not hiding it. They're saying,
some of the companies don't. Some of the companies, right? Some of the companies are very clear in that these other related companies, call them parent companies if you want.
Right.
Mothership companies are responsible, but some of them are masters at,
these holding companies.
like Pruitt's pretty good about, they're people,
clinical services, some we know.
some of them they're really good at coaching their people up.
Yes.
On what to say. We don't really control things. We're just a
consultant.
We provide support. We provide support for what they do.
I know it's the big thing now.
They will ultimately, and then I'll say, well, you send them a policy and procedure. They have to follow that. Well, it's a guideline. We don't really tell them what to do, and ultimately they'll admit that they got to follow. And when you have these mothership companies providing clinical policies and procedures, that's really good evidence of control. And during your trials, we make sure we get all that stuff in. Sometimes we'll tender in a box of policies and procedures. Most, 99% of have nothing to do with the case, except we're showing control. And we tell the jury that. That's, so that their jury's not thinking, well, why did he just tender 1,000 pages here? We're showing. And the only reason we're doing this is because company A doesn't want to accept responsibility, and
it's interesting. I love that. We went through a case in Missouri as a consultant where we had this big corporate structure put together. Nobody cared. Like not one person on that jury gave
Oh God, no!
Right. Couldn't care. They said, "Yeah, that's the way."
They want to see blood on the sidewalk.
They really do. Yeah, they couldn't care less about it. And they want to see the name of that parent company on 100 things that the administrator had to follow.
Right.
It doesn't matter what you argue at that point. You've just showed control. So interesting. So of course we took too long. We only have like 5 minutes left, but that's okay.
And we'll come on again. You may have. This is so much fun. I promise you, if you text me, I'll get it in.
What I think people don't realize is we have spent through AAJ and through the Nursing Home Litigation Group, I don't know, months totaled in different cities all over the country talking about this. When you go to one of these seminars, you want to know where you learn everything? Go to the bar after the seminar's over, put your credit card down, so I'm running a tab, and sit with us and say, what do you think about this? You'll get everything you could possibly need to try a case. So you've got this pressure wound case. Why aren't they settling it?
I think the reason.
It's a good question,
No,
Saul.
I think what happens is, Saul, that and we kind of touched on this earlier, a lot of people out there, and this is not a criticism of anybody, but there's a lot of people out there that, a lot of defense lawyers that don't think any case is worth more than $250.
Yeah.
And a lot of plaintiffs lawyers will take $250. And, on occasion we'll take $250. But, if we have a good case and we think these things are very dangerous in front of the jury. Okay. But they're just not going to pay, 7-figure money on many cases. They're not
Right.
going to do it, and so that's why we pick and choose those pretty carefully. They know that 90% of the time they can get these other lawyers, to take.
And you don't know what a jury's going to do. I mean, as a former defense attorney, even on a good
don't.
plaintiff's case,
Right. You don't
know what a jury's going to do. It's
You
a roll
don't.
of dice.
But it's a pressure wound case. You've got formers. You've got emails that talk about staffing.
Yeah.
You could start seeing where it's going. And I'll be honest, it's you guys, it's Mike Prieto, it's Evan. I mean, I'm thinking if it's one of you three, they may not want to try the case. They may want to get you out and wait for one of those other people and test them.
I think that there's some of that,
Yeah.
Without tooting our own horn, I think that there's not that many cases that get tried, and it's Mike and Evan and I, our firms that are trying them, and they know that we're going to put them through a rough ride. I mean, that doesn't mean I'm not saying we're going to win, but
that's the way it was back in the day in Jersey. It was me, it was Debbie Goff, it was Dave Cohen, Barry Sugarman.
Right.
Everyone else settled, and we were the idiots that were picking jurors all the time. But it's fun. So tell me, what was the verdict?
On that verdict, it was including punitives. It was like 15 million something, but our punitives, we have a 250 cap on punitives.
Right.
So that got, reduced by the judge significantly, but it was a good verdict. And
15 million was a good verdict for you?
Yeah, we'll take that.
Yeah. Well, that's nice. I'm sure there's a lot of people are sitting here going, what? Why are you bullshitting with these people? So I'll get more info from them.
Right.
Thank you.
Yeah.
Lance and Suzanne. I appreciate it. I appreciate you coming on. Hopefully
It's fun.
It was fun. And
it was fun. We'll do it again. Just send me a text this time.
Well, what I want to do next, I've had Mike on. I want to get you, Mike, and Evan on.
Be great.
And just ask about your best trial story and what you think works and what you think doesn't work. I think that would be just absolute gold.
That would be fun. Those are two of my best friends, so that'd be great.
Obviously, I know that because we have all been together too many times. But I do want to talk to you just for a second, because when you guys had the elder law seminar, it was right when you were making the big name change. Tell me a little bit about that, and what's happened with your firm.
Well, we had two partners that one retired. Joe Watkinson's doing mediations. Rob Rawl has gone of counsel and still working on, and he really didn't do nursing home work.
Right.
He did a lot of med mal, and he's working on about 3 or 4 now. And we had brought on Xavier Carter, 4 or 5 years ago. Excellent lawyer, a lot of fun to work with. And then Lindsay started in 2000, but she was not a member of our firm because she had some conflicts, and so we didn't.
Not 2000.
Yeah, 2020. I'm sorry, 2020.
She's been here a long time, but
Right. No, in 2020.
Well, I know. I don't think she's old enough to have come on to your firm in 2000.
Right. And then Andrew's been with us about two and a half years,
Yeah.
and so that so it was a good opportunity to have some younger partners in the firm. Energetic, and we're really excited. Those are 3 rock stars: Andrew King, Lindsay Forlines, and
didn't
Carter.
Lindsay and Lindsay just had a verdict when I came up there. They just finished a trial, didn't they?
it's the trial you've been talking about.
Yeah. So Xavier, Stephen, and I tried the nursing home case, and then Lindsay we had some after the verdict, we were able to I testified on attorney's fees.
Got it.
And Lindsay did some of that work with the jury. And then the next trial was Xavier, Lindsay, and I.
Assisted living.
Assisted living, yeah.
How'd that go?
That went fine. That was the Ant case.
Oh, the famous Ant case, which, by the way, if you're listening to this, we'll have I'll have them on it again. That was the purpose of bringing them on today, was to talk about the Ant case, which we never even got to.
Right.
Real quick, what was the verdict in the Ant case?
The verdict in the Ant case was $3 million.
I'm thinking,
Yeah.
a little over 3, I think.
Yeah.
But that
So-
also included some fees.
Yeah.
No,
So,
was there punitives in there?
Yeah.
Okay.
so Lance and Suzanne, I know the answer to this. If people are listening and they like what they're hearing and they're fascinated by your accents and they want to call you and get some information, how do they get in touch with you? I mean, I know you would be happy to talk to them because you were always happy to talk to me when I was younger.
Well, Saul. Hold on, let me spit out my chewing tobacco real quick.
But if they can just contact you right on your website.
Yeah. Or just email me, and
you'll get back to them in a month.
of course, in a few months, after the statute's run,
So, well, again,
Get on him.
I want to thank Suzanne and Lance Lourie, two, again, personal friends of mine. We've been working together in cases, I think, our whole career just about. Thank you. You guys were really informative and really enjoyable. I really appreciate it.
Well, thank you for
Thanks
having
for
us.
having us. It was fun.
We'll look forward to next time.
And like I told everyone before you heard the interview, it's going to be fun and something you can learn a lot from. Again, it was Lance Lourie and Suzanne Fink, and I love the way Suzanne was able to give everyone some tips about how she reviews the records and what she looks for before even taking a case. And then Lance hit you with, this is what we're thinking about when we try the case. And if you listen and learn from Lance, it's all about the story. It's all about the story. That is our episode this week. I want to thank everyone for listening to The Jury Thinks What, a podcast by trial lawyers for trial lawyers on the Lawyer Minds ecosystem. And we look forward to seeing you next time.
That concludes another episode of the Jury Thinks What podcast, part of the Lawyer Minds ecosystem. Thank you for listening, and we truly hope it was worth your time. Please consider subscribing to the show wherever you listen to podcasts. Explore the other content that Lawyer Minds has to offer, and engage with us on social media. Your feedback and ideas are always welcomed. See you next time.